want to say that we can't talk about all traditional divorce cases as if they're the same. I personally continue to practice traditionally and think that I do and many lawyers do a good job of protecting children. What we know about those cases, however, in the traditional model is that they don't focus on the best interests of the children. People have a tendency to fight for more time than perhaps is appropriate to the children in order to try to reduce payments, and children can often feel like they are not so much being valued because the parents love them and care for them. It's as if they are some kind of stake in the outcome. Their placement generates a financial result for a parent. And so the collaborative process, I think, is the first process where people really are able to detach from finances, make finances a secondary consideration after establishing a good placement outcome. In a traditional case, if the parties reach an outcome, that's marvelous, and it can proceed, and they can, go forward and make their final agreement. In a collaborative case, they agree in advance, both with their lawyers, with their mental health professional coaches. They agree on the idea of developing a statement about what's important to them. Chiefly in families with young children or even older children, those mission statements, those goals and objectives of the process include support, care, and keeping the children's interests first and foremost. Now, that can happen in a collaborative process in a number of different arenas, if you will, in the lawyer's office, in the mental health professional's office as the coaches, or in concert with coaches and a child specialist. Here's a place where children are made to feel heard and valued. In a collaborative case, they can give input to a child specialist as opposed to a guardian ad litem. A guardian ad litem in a traditional case oftentimes is an extremely well-intentioned individual whose training and background is legal and legal exclusively, and the input that they seek and elicit is not necessarily input that is helpful overall to understanding what the child is experiencing and understanding where the children are developmentally. Conventional approach to divorce centers on the idea that the parties to the action, the husband and the wife, are opposed and in opposition to one another on almost every point. And when I think of the ways even in which we communicate, in a conventional divorce, you might sit in a meeting with the other lawyer and you might have to ask the other lawyer for permission to address that client, because under the rules of ethics, the conventional understanding is I can't talk to your client unless I have your permission, and I certainly can't do that by separate email or in a telephone conference call or anything of the sort. So communication becomes very direct in a collaborative case, and in fact there are many instances in which we waive that kind of communication so that we can schedule with group emails. I can send an email to your client saying our meeting is confirmed for this time. We talk to one another informally. We have the ability to reach out across a table in an effort to understand and care about the outcomes for the other person. Were I to do that in a conventional case, the conventional case would be shockingly unusual because I'm supposed to be aligned 100% with my client, not about my client's interest, not about what is motivating my client's idea of the correct solution, I'm supposed to look at my client's position. My client says, I don't want the house, I want it sold. I don't want my other spouse in the house with the children. In a collaborative case, we might say, why do you think it's okay for your children to move outside of that home? You know, let's look at something underneath the position articulated by the person and look towards their goals and the reasons that are motivating those goals.